Everyone, this is Ruby Powers and with Board Certified Immigration Attorney with Powers Law Group. And today I wanted to talk about working in the US, non-immigrant employment-based visas. So I am board certified. The law firm's 15 years old. I'm 14 years old. I've been practicing 15 years. And I'm also a author and a professor at a couple institutions. And we are a full service immigration law firm, and with a handful of attorneys, we're able to help individuals all over the world with their U.S. immigration needs. So I just wanted to talk about the typical non-immigrant worker visas that you consider, and then just go briefly into the permanent worker, even though this is non-immigrant, temporary, just to let you know where it could lead to some cases, and then just some other considerations. So the temporary non-immigrant worker, so to come to the US on a non-immigrant visa, the concept is you're coming here just temporarily for that short duration of period. It could be 6 months, a year, 2 years, 5 years, 7 years, but it's for that specific visa. And then you, in some cases, you can bring dependents, and you're going to come do that purpose, and you're going to leave. And there's lots of different ways you could be applying for it, either at the consulate or with a change of status or extension of status here in the United States, so depending on the visa and the circumstance, and the timing as well. So if you were to go to the USCIS website, you could see a lot of these different non-immigrant visas. So one that we see and assist a lot of individuals are for anything from an E1, which is the treaty trader and qualified employees. And this, again, we've done this on different sessions, but you need to have a treaty between your country and the United States to be eligible for this. The E2 is another hot one with the treaty investors and qualified employees. And we see a lot of those as well. And that has reciprocity depending on the treaty between the country and the United States. We also see E3s with Australians, special occupation, H1Bs. Those are pretty popular, and unless you're CAP exempt, you will apply for those in March of every year for a October start date. Then we also have the H2A and H2B, which are temporary. H2A is a temporary seasonal agricultural worker, and the H2B, a temporary non-agricultural workers. And they open those up twice a year for the CAP, and there's been a lot of demand for those visas and the labor shortage in the last couple of years. The H3 is a trainee, so the individual can come here for various reasons, but you need to have a training program, and we've done a lot of those as well, and it can be a great opportunity to come to the United States for short term to get that training and then return back. I is foreign press, radio, film, foreign information media. The L's are very popular as well, the L1A, L1B, or blanket L. And so that's when L1A is when there's an intercompany transferee or manager executive position. They come here. That has a validity of 7 years. The L1B is intercompany transferee, and they come here with specialized knowledge, and that's 5 years. Whenever they are outside of the country, that time doesn't count against them, and they can recapture that. The other thing to note before I finish this slide is to note that the H1B and the L1A and L1B are dual intent visas. So that means you can have the non-immigrant and immigrant intent. But for the most part, we're talking about non-immigrant visas. There's the O1. And the persons with extraordinary ability in science, arts, education, business, athletics, motion picture, or TV. And two, the people that are accompanying them, like entourage and helping assist them, and again, we're also showing all the dependents visas, and everything has a dependent visa as well. P1A is internationally acclaimed athletes. They can also bring in dependent. And there's the other P visas as entertainers, performers, and artists. Q1 is participating in international cultural exchange. It's usually for people who are going to work at Epcot or something for Disney, but this does exist. This is one that doesn't have a dependent visa. The R1 is religious worker, and we have the TN visa for those who are from Canada or Mexico, and dependents are called a TD. Now, those were the non-immigrant visas, and there is a way for people to get a green card, legal permanent residency. Now, let me just explain something. Maybe it's sometimes it can be a little hard to understand, but if you're on a non-immigrant visa, there might be a pathway to a more permanent or immigrant pathway for legal permanent residency. But you also need to watch your immigrant, non-immigrant intent. So usually when you're applying for one of these permanent worker immigrant intents, that could be contradictory to your non-immigrant visa. So you have to pay attention to the timing, and if your visa has a dual intent provision to it, like we said, the H-1B and the L-1A and L-1B and L-blanket do. But also, just because you're applying for one of these permanent worker petitions doesn't mean that you actually are allowed to be in the US if you don't have an underlying visa. So that sometimes people get that confused. Like the labor certification perm process, for example, you need to have another visa that allows you to stay in the United States. If you want to be doing that while you're in the United States, you could do it abroad. Actually, most of these petitions can be done abroad as a permanent worker. And so there's other things to note about the student and exchange visitors. So I used to work at the International Student Office at UT, like about 22 years ago. Oh my goodness, so long ago. And so there's the F1 academic students, F2 are the dependents of F1s, F3 are national academic commuter students for Canadians and Mexicans. We also have the M1 of vocational students. M2 are the spousal dependents of the M1, and we have an M3 Canadian or Mexican national vocational commuter visa. We also have the J1 with exchange visitors that also could be used for au pairs as well, and some medical professionals. So it's J1 is educational cultural exchange programs. It's usually provided by an organization that is allowed and authorized to provide the J1, and the J2 are the dependents of the J1. Now, why do we mention these? Because a lot of these are not necessarily working. Some of them could be under the J1 specifically, but because sometimes it can be a pathway to another visa. And we often see F1s get the optional practical training and then get an H-1B. And so we've also seen J1s go to other visas as long as they didn't have a restriction or they overcame that 2-year restriction. So there's also the possibility of coming temporarily for business under some of these other ways, including the B1. So a lot of times we always say B2, but there is the B1. And the B1 is a temporary business visitor to conduct activities of a commercial or professional nature, so that they would be coming in on doing that business and leaving. But there's some restrictions on it, and really you can't be earning money in the United States from a US entity here. So you have to really look at the provisions on that. It doesn't allow you to work, but you could be consulting, you can negotiate a contract, attend a conference. It's very limited scope in nature. The visa waiver program also has certain limited scope as well. And there's also the temporary visa for business limited to Guam, the GB temporary visa to Guam. So this is potentially an option when somebody needs to come in very temporarily and can meet these qualifications. So, I mean, it's important that employers must verify the individual whom they are planned to employ, continue to employ, is authorized to accept work authorization. As employer, you may require services of a non-citizen to work at your company. If the individual is already a green card holder, you may hire the individual, but you must comply with the employment verification. If the non-citizen is not already a permanent resident, you need to file a petition so they can have the appropriate classification. And employees, no non-citizen may accept employment unless they have been authorized to do so. And some of those who might have been admitted, as a permanent resident, granted asylum, or admitted in work-related, may have employment authorization as a direct result of that status. Some others need to apply. But if you have any questions about this, and this isn't like legal advice, but it's good to really advise to have a consultation. And sometimes we just get on retainers that we're available when there's questions in the future to be available for the companies. So that was a brief overview of non-immigrant employment-based visas that exist. Just sort of like a big picture. There's a lot of different ones, but I find that a lot of them are very, very specific. And so usually when we have a consultation, we ask that individual what they're looking for, and then we try to narrow it down to just a couple options, and then we do some homework, do a little research, come back and narrow it down to the final strategy. So thanks so much for watching. Today was the Working in the U.S. Non-Immigrant Employment-Based Work Visas. We have a handful of attorneys available who speak everything from Spanish, Russian, Ukrainian, and we also have Turkish and French translators available as well on staff and helpful. We are located in the Heights, but we also have a location in the Woodlands as well. And we'd be glad to help you. Feel free to give us a call at 713-589-2085 and let us know if you have any questions. If you'd like to have a consultation, we help small to mid-sized businesses with their needs as well as individuals. Thanks so much for watching.